pay Hank and send him a copy of this, but I need to do a paragraph before because his BP is going to go through the roof. He's going to have a heart attack when he reads that.
What did Greshik say?
Well, he said, first of all, he started his article saying an ex-con, a car thief, a parole violator, which is both are false, talks about the blood spatter being spatter and not contact stains. I mean, things that are factually documented in the case. It's not what Hank is saying or what I'm saying. We have expert, reports. I mean, it's documented in all the legal briefs. It's not that we're making things up. And I thought, what is wrong with him? He's usually neutral at best, not very thorough in his review, but this time he's really siding with the prosecution. So I don't know if he had an argument with Hank in one of his last interviews or what, but that was not good. So where we're at now is the Supreme Court really is looking at a very, very technical aspect as to why he should be entitled or not to use the Civil Rights Act to apply for DNA testing. Interestingly, the federal courts of appeal in the United States, there are 12, 6 of them have granted DNA testing through this route. 3 of them have refused, and the other remaining circuit courts have not been confronted to the issue. And obviously we knew that what would come up, and a lot of DAs are saying, well, they're not worried about whether Hank is innocent or what, if we should review the evidence. They're just saying, hang on, if we open that door, we're going to be, the courts are going to be clogged with requests. People are going to want DNA testing left, right, and center. And Hank's attorney addressed that question. I think Justice Scalia addressed that very early on in the argument. And Rob just told him, he said, from the 6 circuit courts who have allowed that route for DNA testing, none of them have been clogged with demands. So it's not like it's going to create a rush of motions for DNA testing through the Civil Rights Act. But technically, it is complicated beside the precedent it's going to set. And I'm trying to make it simple. And if I recall the arguments from some of the justices and some of their questions, basically, when you want the evidence to be looked at, you go through the habeas process, which is really the body of what your defense is going to use to bring the evidence to be reviewed. And Rob was very bright in explaining this when Justice Alito asked him and said, but surely this is got to be an habeas issue. And he said no, because an habeas issue challenges the conviction and the confinement, the constitutionality of the confinement. I am not challenging my client's sentence, and I'm not challenging the constitutionality of his confinement. I want to be able to access the evidence, then I can know whether my client is guilty or innocent. So it's a very fine line. I would say that we're cautiously optimistic. We have 2 newcomers on the court, so it's hard to see how Sotomayor and Kagan are going to vote. I thought their questions were very interesting, very on point. I mean, Sotomayor was very aggressive in her questioning. Justice Breyer was just outstanding, as he always is. And even Justice Scalia made some very interesting remarks and thought that maybe this question really does need consideration and means that the standards needs to be expanded. So we're not over-optimistic because we learn here not to be optimistic. I'll believe it when I see it written down,
Did every one of the justices make a comment or a question?
Alito just made one comment about the habeas issue. Kennedy made a couple of questions that really floored us and I thought was going to give me a heart attack, and he just basically addressed Hank attorney and said, well, if this is all what your case is about, then we shouldn't have granted a stay in the first place. And then we went, oh my God. It was like...
This was Kennedy?
Yeah, it was Justice Kennedy. The only one who did not speak a word was Justice Thomas.
Oh.
And apparently for the last 10 years, he has never asked a question during oral arguments. He did whisper something to Scalia's ear and to Justice Breyer's ear. Sotomayor and Kagan asked questions, quite technical. The first one who got into question, and it was visually quite incredible because you sit obviously lower than the justices in that huge room. It's like a cathedral. It's very intimidating. You can imagine for attorneys how scary it is. And Justice Ginsburg was sitting, this tiny little thing, in that huge chair. And honestly, she seemed so frail, I felt like, picking her up in my hands and putting her in cotton wool so that she wouldn't break. And Rob had not finished his third sentence, and wow, she started questioning, and her mind was extremely sharp. And all of them, I must say that the speed of their reactions, their knowledge of the case, and remember that usually when they hold oral arguments, they have 2 in the morning, 2 in the afternoon. So they have to be abreast with a lot of information, and they were really fast moving in their questions. But at one point, even Justice Breyer tried to corner Rob. He just reviewed different previous rulings, and then he said, okay, we've looked at this, this, and that, but can you tell me about a case who raises this point? And everybody's like, oh my God. And he says, yes, Your Honor, in Edwards, you wrote that, and it was just smooth. Rob is not only a law professor, he's a very talented attorney. And when the question went on to the DA's attorney, Lynn Switzer attorney, Mr. Coleman, it was just very interesting to see how the man had no argument. He had none. The only thing he could say, and they grilled him as hard as they had grilled Rob. In fact, Rob was very bright because each attorney has 20 minutes to present the case, and then, there are questions from the justices. He talked for 15 minutes, and then he said, Your Honor, can I reserve my remaining 5 minutes? And they did, and I said, okay. So he was able to come back after Mr. Coleman had spoken. And basically, Mr. Coleman makes the point that this is a habeas issue, that Hank is gaming the system when the state has been gaming the system for 15 years and denying him DNA testing. And then they started grilling him really hard, and we were sitting there with Natalie just enjoying ourselves.
Hank's daughter.
And he had no answer. And they really tried, they even tried to put word in his mouth to help him. It was pathetic. And about 6 or 7, about 6 or 7 times, the only answer he had, he said, they were not asking him whether he agreed or not. They were asking him specific questions so he could explain his legal reasoning, and he would just say, I disagree, Your Honor. I disagree. And about 4 times he cut them off when they were talking to him. I mean, but the fact that he did not find the legal reasoning doesn't mean the justices are not going to find it. So I'm cautiously optimistic. I think Hank is lucky, and he knows it. I know he was ecstatic at his attorney's work. He's not somebody who pays compliments very often.
This is Rob Owen.
Yeah, and Doug Robinson in DC, and Maria Cruz also in New York. And he has excellent attorney, which unfortunately tells you a lot about the state of the system in Texas. That even with excellent attorneys, here you are 15 years later, you still haven't gotten relief. The only major difference it made a difference on 2 accounts. The first difference is that Hank is still alive today. If Hank hadn't had such good attorneys, he would have been executed a long time ago. And the second difference it made is that the Supreme Court accepted to review the case. So, will they prevail or not? We don't really want to speculate. We think that the question, I mean, to me, beside my personal situation for Hank, it's not even about Hank's case. It's how is it possible in a nation, in the United States, that in some states, some death row prisoners can use the Civil Rights Act to apply for DNA testing, and in other states they can't.
How does that break down? Because
well, it means that certain circuit courts will grant you.
How many circuit courts are there?
12. There are 12.
Okay.
6 at the moment have granted DNA testing through the Civil Rights Act. 3 have denied, and the others have never been confronted to that question yet.
So right now it's a majority that do allow it.
Absolutely, and it means that if people
shouldn't that give a little
it should resonate.
weight?
It should resonate, and also the fact that people are supposedly equal before the law. And that just says that the federal statutes doesn't need to be reviewed, and I hope they're not going to restrict it the other way, that nobody has the right to use the Civil Rights Act to grant DNA testing. That would be